interrupt myself here because it became very dark. I couldn't see what I was reading here. Okay, so I think that should be fine now. Okay, removal of the practitioner. I think it is discussed in your study notes, the case of Oak Bay versus Tegeta, where it's one of the Gupta companies. You'll see that about half of the case law we have at the moment on business rescue concerns one of the companies in the Gupta groups, where there was an application for a removal by okay, now let's leave it this slide here, because we have the very three specific grounds that you can use. The other section that you can use for the removal of a practitioner is section 139.2, and this one you can use at any stage during business rescue, even after a plan has been approved, although that would probably not be very practical. The grounds are more numerous. There are several grounds for removal in terms of section 139. There's incompetence or failure to perform the duties of a practitioner, failure to exercise the proper degree of care, engaging in illegal acts or conduct. Section 131 requirements have not been met or are no longer met. There's a conflict of interest or lack of independence. Now, section 138 already requires independence from the company. So the fact that there is a separate ground, conflict of interest or lack of independence, seems to imply that we're talking about other conflicts of interest or lack of independence from others and not the company. And for that, you have the Oak Bay versus Tegeta case, which, as I said, I believe is in your study notes, where the same practitioners were appointed for several companies in the group, or at least two companies in the same group, and the company applied or one of the affected persons, which was also a company, applied for removal of the practitioners because arguing that there was a conflict of interest. You cannot be the practitioner of two companies in the same group, especially when the one has claims against the other. And the court said, well, at this stage, there's no indication that there is a conflict of interest. Should there be, then of course it will be different. But the mere fact that you have the same business rescue practitioners for both companies, that in itself is not necessarily a conflict of interest. Then incapacitated and unable to perform functions. That's really when a business rescue practitioner becomes ill or isn't able to perform his or her duties anymore. Then if the business rescue practitioner doesn't resign, maybe because he or she is in a coma, then you can apply to court. It's actually ironic that even somebody who can clearly not do the job anymore, that you still have to apply to court for this person to be removed as the business rescue practitioner. It shouldn't have been so difficult, but unfortunately it is. Right, the question now is, who replaces a business rescue practitioner who has been removed? Section 139.3, which very clearly applies to both removals in terms of section 130 and section 139.2, states that that the company or creditor who nominated the previous practitioner must appoint the new practitioner if the practitioner dies, resigns, or is removed from office. Section 130, however, specifically states that the court must, if the court sets aside the appointment of the business rescue practitioner in terms of Section 130, then the court must appoint a new business rescue practitioner recommended by or acceptable to the independent creditors represented in the hearing before the court. So if the practitioner is removed in terms of Section 130, then that practitioner, the replacement practitioner, must be appointed on the recommendation of independent creditors. However, if the practitioner is removed in terms of Section 139(3), irrespective of whether that practitioner was originally appointed by the court or by the company, because the business rescue proceedings commenced by a filing of a resolution. You can use Section 139, but it says the company or creditor who nominated the previous practitioner. Now, the company only nominates a practitioner when the practitioner is appointed after the filing of a board resolution, which means that if you remove that practitioner in terms of Section 139 and not in terms of Section 130, then the company gets to nominate the next practitioner again. Even though the previous practitioner was not a very good choice, the company can appoint the new practitioner. So it makes a big difference whether you apply for the removal of a practitioner in terms of Section 130 or Section 139, because that will determine who gets to appoint the new practitioner. On the other hand, if the practitioner was appointed by the court, now the Act talks about a creditor, but the application for business rescue, for a business rescue order, is not necessarily done by a creditor. It could be any affected person. So in Tayop versus Shiva, which I think is also in your notes, the court held that, and it was the Supreme Court of Appeal, that we must read creditor as affected person. So we'll just change the legislation. So the affected person who nominated the previous practitioner, which would obviously then be the affected person who applied for the business rescue order, that person gets the right to appoint the new practitioner or nominate the new practitioner. So that's important for replacement of a practitioner in cases where the business rescue was commenced by filing of a board resolution, because there it will depend on what stage it is. Or under what section. If it's Section 130, then it's the independent creditors. If you use Section 139, which has more grounds for removal and can also be used after approval of the plan, then it's the company that gets to choose the business rescue practitioner again. So that was, Shiva Uranium versus Tayop. I'm not sure, maybe it's not discussed in your notes. I'm not sure now anymore. But anyway, in Shiva Uranium versus Tayop, that's what the Constitutional Court actually confirmed, but it was a decision of the Supreme Court of Appeal that if you apply for a replacement in terms of Section 139, then, or apply for a removal in terms of Section 139, then the company or then affected person who nominated the previous practitioner gets to choose the new one. So if the previous practitioner was appointed by the board, then it's the board that gets to choose the new practitioner again. Right, study unit 6. Powers, duties, and liabilities of the business rescue practitioner. The Act states that the business rescue practitioner takes over full management control of the company in substitution for its board and pre-existing management, but may delegate powers or functions to a director or manager. Now, there is a case which I haven't detailed here because it's a very recent one, and I don't think you need to know that for purposes of this course at this stage. But it's interesting to note it was the Supreme Court of Appeal case, once again, the Gupta companies, where a wholly owned subsidiary had a claim against its holding company. The question now, and both were in business rescue. The question then was, who has the right to vote on behalf of the subsidiary, who is the creditor company, on the rescue plan of the holding company? The directors of the subsidiary argued that they have the right to vote because they are still have the right to take decisions on the running of the company and the directions the company must take and so forth. But the business rescue practitioners of the subsidiary said, in terms of the Act, we have taken over full management control of the company, which means that we have the right to vote on the rescue plan of a debtor company on behalf of the creditor company. And in this case, the Supreme Court of Appeal agreed with them and said there are various provisions in Chapter 6 which makes it clear that the business rescue practitioners have the control, they have the more rights than anybody else, and they have the vote for this plan.